Well, hello, everybody, and welcome to Shore Solutions, the webinar, which will also be broadcast to Shore Solutions, the podcast. My name is Jay Shorr. I am the founder and CEO of Shore Solutions, a national practice management consulting company specializing in the operational, administrative, and financial health and guidance of your aesthetic, cosmetic, surgical, and med spa practice. Today, I have the pleasure of having two guests on this webinar. And those of you who have joined my webinars and podcasts, this webinar will be converted to a podcast. But I have two attorneys. Don't say, oh no, and don't run. These are the good guys. These are the good guy attorneys. They're on our side. They're not the ones that come afterwards. They protect us from us in spite of us. I have Byrd Adatto, and Brad is a partner, co-founder of Byrd Adatto Law Firm based out of the Dallas metropolitan area. And I also have Alex Thiersch. Alex is the president, founder of AmSpa. Everybody knows AmSpa, also a partner of Byrd Adatto. And today we're going to be having about navigating the landscape. And in navigating the landscape of our med spas and our practices, it is such a wide and diverse thing of what we have to do, what we should do. So it's navigating med spa compliance, what we need to know. It's only an hour. So listen up, ladies and gentlemen. You are getting an hour of free legal advice. Now, I know that the free legal advice that I get from Brad, because I call Brad all the time, I get free legal advice, which is one word. What would that word be if anybody knows? It depends. And I'm asking, well, is it because of my age? I need depends. Or is he sharing with me? It depends. So I always make the joke, oh boy, I'm going to call Brad and I know what answer I'm going to get. So let's get started. When we talk about navigating med spas and what you need to know, before we begin, let's introduce ourselves. We're going to ask questions. Call in, ask questions live rather than in chat. Stay till the end for questions and answers because we're going to give it to all of you, and the recording will be available when the webinar ends. I will share with you that I have no formal disclosures about this. This is not monetized in any way, and our guests are attorneys, and they have no formal disclosures about what's going to be discussed in this. So, Brad, take it away. If you can give a 30-second of who you are, I appreciate it, and then we'll go right to Alex.
Hey, everybody. Jay, thanks for the invite. Glad to be here with you guys. But as Jay was saying, I am a lawyer with one of the founders of Byrd Adatto, and we are a law firm based in Dallas and Chicago. We have, we're really what we're known for is being business attorneys that represent healthcare practices. The vast majority of our practices that we work with happen to be in the aesthetic market. So plastic surgeons, dermatologists, med spa, wellness clinics. So it's an area that we're very familiar with. And like all business attorneys, we understand how a business works, but as Jay was alluding to, you have to follow a lot of healthcare laws on top of that. And so that's what we do every day at our shop.
Yeah, well, I mean, really, it's really tough to introduce myself after Brad and you because you guys are both just such luminaries, and we've all known each other for a very long time. So this will be fun. But appreciate the intro, appreciate the invite. Alex Thiersch, I call myself a recovering attorney because although I still am a lawyer, I still am licensed. I spend the overwhelming majority of my time, in fact, all of my time, doing running AmSpa, the American Med Spa Association, and we're, I founded AmSpa because of the fact that we wanted to make sure that folks were compliant. So it's really what we do. Our job as an association is to make sure that everyone is armed with the information that they need so they can operate safely and compliantly. We want to elevate the industry and make everybody safer and better. So that's what we do. But I am still unfortunately a lawyer, and it's really tough to shed that skin once you get going in that direction.
Well, I like to say the good kind of lawyers because I remember when I owned my practice. I will make a disclaimer. I am not a physician. I say that because I'll be speaking about my former practice, which I was a partner with here in South Florida, a very large practice. And many of you know my story. I'm not going to get into it today. And then I went into the business side of medicine, realizing about all the doctors and practitioners that needed the help and guidance. So, one thing I want to ask is when you ask yourself, are all practitioners licensed and certified according to state regulations? And when I say state, I'm going to say state. I'm going to include commonwealths because we have Massachusetts, we have Pennsylvania, we have Virginia, we have Kentucky. For the purpose of today's discussion, I'm not going to change my verbiage going to commonwealth every time I mention state. I'm going to use all the 50 states within the contiguous, in the 50 states that we have here. So Brad, are all practitioners licensed and certified, meaning doctors, nurses, PAs, nurse practitioners, estheticians, scrub techs? Many are, and many are not. So how do we navigate around this?
Yeah, it's a great question, Jay, and it's almost like a trick question. And the trick of it is a lot of times when it comes to individuals, you may get a license from a particular state. So going back to it, you're a nurse practitioner, you're licensed by that nursing board. So that's who you answer to. That's how you get your license. The certification, though, is a separate piece. So my scope of practice as a nurse practitioner, I can do a host of things as a advanced practitioner. I can help do A, B, or C, and a lot of that is dependent on what does my state say. Do I have to answer to a doctor? Do I have to be supervised by a doctor? And then to the second part of the question, the certification. Certifications are a kind of tricky situation because most boards don't recognize a quote certification in the sense of like, I trained on a laser, or I trained how to give Botox, or I trained at this. You may have a piece of paper that said you took a Botox course or a laser course, which is important because that's a skill that you need to do to actually touch that patient. But understand where I think we often see the compliance concern would be someone is certified on something, but it's outside the scope of their authority. So to your point, Jay, earlier, yeah, there are individuals out there that are unlicensed, meaning there's no nursing board or medical board or that had allowed them to touch that patient, but they get certified by some course in Vegas where they learned how to fire a laser. Just because you were certified does not always mean in that particular state you can actually render that service. So hopefully that's kind of helps. And I know Alex probably has some hot sports opinion on that one too.
Then I'll have a follow up question to that. So go ahead, Alex.
No, I mean, I think, we always get a little bit nervous when people start talking about how they are certified, because really a certification can be, we could issue a certification after this webinar if we wanted. We can issue a certification for pretty much anything, and that doesn't necessarily mean anything when you start talking to the states, the medical boards, and things like that. If you're a license holder, typically that is going to mean, almost always that's going to mean in all 50 states, that the state has passed some sort of a law that allows you to be licensed as whatever they are defining you as a license. So if you're a nurse practitioner, you're a licensed nurse practitioner, MD, things like that. Normally, and think in most of the license holders in aesthetics and in medicine, that's pretty self-evident. Where it gets a little tricky is when you get into things like estheticians who are doing medical treatments, when you get into medical assistants who are unlicensed, but they're also doing medical treatment. So it's tricky, but at the same time, I think the main thing is the licensees are really what you want to focus on when it comes to the state, because that's what the state actually recognizes, is who is licensed under that state.
All right. So I'm going to do a follow up question because in the state of Florida, where I am, a nurse or an esthetician, a nurse RN, LPN nurse, regardless of what anybody says, is not allowed to inject or fire a laser. All right. Now, an esthetician may fire a laser if they have an electrology license, but only for hair removal. And the craziest thing is a podiatrist can do laser hair removal, but only from the knee down. Go figure. I didn't make these laws. These are according to their boards. Now, the question that I have for a follow up is in Florida, you can't, but I was led to believe, for example, in Illinois, that under the direction of an MDDO, a medical assistant who is neither licensed or certified under the direction of the doctor may perform specific services that other states you're not allowed to do. Alex, since you're from that Chicago area, can you comment on that?
Yeah, there's it's actually also a trick question, in many ways, but that's honestly how most states, not all states, but most states operate by saying it's up to the physician, whoever that supervising, delegating person is, whether it's a physician or if you're in a state that allows it, a PA or an NP. It's up to them to determine who they can delegate to, who is qualified and experienced enough to perform that particular treatment. Now, I say it's a trick question because um, the medical boards and the investigators who are going to be enforcing these laws don't always necessarily see it that way. So you're absolutely right, Jay. In Illinois, I could delegate certain treatments under the law, under the letter of the law, to someone who is an unlicensed, quote, uncertified individual, and they could perform that treatment. And if I deemed them to be qualified, then that would be kind of on me. However, a lot of that is not really what is found under the standard of care, which is kind of a separate issue. So the medical boards oftentimes are going to say, well, maybe that's allowed, but really, under the standard of care, as a physician, you shouldn't be delegating an injectable treatment, for example, to a lawyer who has no training, right? That you shouldn't be doing that, and so it's not necessarily cut and dry to say, well, yeah, in the state of Illinois and Texas is the same way, as Brad can attest to. It's not really enough to say, well, yeah, you can do it, because really what it comes down to is, are you able to justify and defend that decision in the event that there is an injury, some sort of a bad outcome, side effect, whatever that is, or if you're investigated by the medical board, you're going to need to defend the fact that you delegated that treatment to somebody who was not trained and not licensed.
All right, so let's talk about that, because in order to do that, the doctor would then have to have had a delegation agreement, right? Are they going to be creating this delegation agreement like post haste after the incident? Like, who would ever know that if you backdate that? I'm not acknowledging that that should be done. However, who's going to hang for it? The person who allowed that person to do it, correct?
Yeah, and I want to jump in here on that too, to add some more. I agree with what Alex said also, and going back to Florida versus Illinois, a lot of times, so in the state of Florida, the way the medical board tells a physician, hey, physician, if you believe someone can do something, you can delegate it to them. So going back to your statement, Jay, I'm going to delegate to this RN to this injection or this laser, and the nursing board would say, no, 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 you can't do that. That's not within your scope. Now you have a conflict. This happens often with the boards, where as a physician, I'm allowed to delegate it to that RN if I want to. Now the RN has to figure out, how do I feel about my license being jeopardized by being delegated to, which is to Alex's point, everybody can read the rules. I mean, anyone can look them up on the internet. That's an important element. The next most important element is then, how are they enforced and how are they viewed from an enforcement perspective? Because that's what we as lawyers care about, because that goes back to the risk associated with that delegation. I'm delegating to this medical assistant in Illinois. How do they feel about that particular procedure? And to your point, Jay, the doc, generally speaking, or physician assistant, sometimes a nurse practitioner, their license are the ones that are most in jeopardy when you're delegating to a non-physician. And then one more add-on to that is, when it comes to delegation, there's a couple of states when someone goes, hey, I read that a doctor can delegate this laser treatment, and it's okay. I'm like, yeah, that's actually correct. He can delegate to the unlicensed person. That's a delegation. The second part of that rule is supervision. And the doctor must, read the rest of the sentence, be in the room with the laser tech when they fire it. Well, yeah, he can delegate to it. The doc's still standing there. So they forget to read the second part of that, which is delegation versus and supervision. There's an and there for a reason. And so sometimes people hear that you can do something, but they don't realize that those two have to be read in conjunction with each other.
Very interesting. It's wonder how one question will lead to several subparts. The several subparts are naturally the business and professional regulations, the governing body that has the licensure, naturally the Board of Cosmetology, and here in Florida, which will govern the estheticians, and the Board of Nursing. They say that you can't, right? So although the doctor said it was okay, now they're going to be in the potential situation to have their licenses revoked by by their licensing bodies. However, medical assistants don't have a license. So now what?
Yeah, what's interesting about that is that when a situation like that happens, and it can absolutely happen, really the license holder is going to be the one at risk. And we see this sometimes when non licensed folks, just business people, are owning through MSOs or whatever structure they have when they're owning businesses. When it comes to the medical board investigating, they are going to go after the folks that they have jurisdiction over, which is those license holders. So if you're a medical assistant and you don't have a license, your license is not at risk. Doesn't mean that the med spa itself or the practice itself, the doctor itself, the supervising physician, whoever that might be, isn't at risk. And we should always say that if the practice or whatever happens is egregious enough, typically most attorney general have jurisdiction as well, and they can open up, and we have seen this, open up criminal investigations, and that doesn't necessarily matter whether you're licensed or not. But it's really a good point. And I think that the bigger picture that we deal with as an association all the time is that when you get these conflicts between these boards, and it happens more than you would think. And it's not just that, it's conflicts between the boards, it's conflicts between individual board members on how they interpret things, it's conflicts between understanding of what a particular treatment is and who should be able to do it. It really is complex, and we need to do a much better job as an industry of educating the board so that they understand how we do it, and understand what the actual reality is, and if necessary, make changes.
Good. Brad?
And I want to add something to what he just said, Jay, real quick, which is going back to just because you can doesn't mean you should. And there, and so going back to states like Texas, where a physician can delegate to anyone they want to do a particular procedure. If you've never seen that person touch a patient, you don't really know if they have the skill set. Just because you can delegate it to them doesn't mean you should. And again, from our perspectives as lawyers, we're thinking about, if you go in front of the medical board or nursing board, we want to put you in the most defensible position. So now you have to go in front of a licensing board and explain to the board why you're allowing someone to inject something right next to someone's eye, and they've never had any formal anatomy training. Do you feel comfortable with that? And I actually know plastic surgeons. Like, I've seen this person inject. They're better than I am. And I know they're not licensed, but they've been doing it for 20 years. They're amazing. Great. So long as you feel comfortable with that. And again, nothing against those who don't have those same licenses. It's just understanding, to your point, Jay and Alex, the physician ultimately has the responsibility who they're delegating to and who they're supervising.
Wow, just because you can doesn't mean you should. It sounds like, God rest their souls, it sounds like something my mom and dad used to say to me as a little boy, but that still resonates. So now, Brad, I'm going to lead this to you because you brought up an issue a couple minutes ago about the doctor being in the room. Now, there are adages about direct and indirect supervision, where direct supervision doesn't necessarily mean you have to be in the room. Some say that you have to be in the facility, and some say you have to be within an earshot of contactability. Do you want to expand on that just briefly?
Yeah, absolutely. I always break it down to three elements that when it comes to supervision. So the first one is you're in the room with them, and that's typically, it's such a complex procedure, the doctor has to be standing there. Normally, as you can imagine, that's for invasive surgeries or invasive procedures, are very, even though it's non-invasive, very restrictive. So a lot of times they're in the room. The second category is what you were kind of referencing, is immediately available. Generally speaking, depending on that state, that might mean that they're in the same office building, not the same suite even, but at that same kind of practice. And then you have the third element, which is kind of general supervision, which is typically you'll see it in a state called appropriate supervision. And when you kind of dive deeper into that, means they're available. Availability is really interesting because some states available is within 25 miles or a certain amount of minutes, or immediately available means you get them on the call immediately. So all of those are different elements when it comes to the supervision. So in the room, on site, or available. And I always tell people, look, if you're the doctor and you're going to go with immediately available, no, actually, no matter which version you take, you should have great processes and protocols in place. So it's very clear that how the patient should be treated. And if an adverse event happens, how do they react to that? What are then the next steps they're supposed to do? Because when we, again, going back to the defensible position, something bad happened, but that person knew exactly what to do because they had been trained on it. And the policy said, these are the next few steps that you're supposed to do. So again, that goes back to no matter what type of supervision that you're required to do, definitely have great written out protocols that, of course, the supervising physician should be aware of. And I know, Alex, you have some also thoughts on when someone's not available. How should a med spa or a practice respond?
There's a
Yeah,
lot of those, a lot of
yeah.
doctors, even the NPs who have to do the GFEs, the good faith exams, are not on site when, these corporate facilities, for example, they allow some of these people to perform services and the direct supervisor, whether it's the NPPA or doctor, aren't there.
And that's not necessarily against the law, or as Brad said, even if you can do it, that's not necessarily inappropriate. There's it really depends on the type of treatment and who's performing the treatment is what you want to focus on. So an advanced procedure, obviously, you are going to want to have more supervision than a less advanced procedure. So it's not necessarily incorrect to not have the physician on site, provided you have the protocols, as Brad was saying, in place, and the proper delegation procedures, all of those things in place where you can deal with bad outcomes or side effects as they happen. The other thing that Brad was mentioning that I think is important is that, particularly in aesthetics and in med spas, oftentimes there will be times when the supervising physician or NPPA, if that's the case, is not available for whatever reason. They are traveling, they're overseas, they're in Africa on a safari, or whatever it might be, or you just can't reach them. In those cases, it's very important through your protocols to have some sort of a backup. You've got to be able to reach somebody. And it's especially if you're an RN or an esthetician, laser tech, one of those who doesn't have prescriptive authority, you can't actually make diagnoses. It's going to be really difficult for you to do anything if you can't get a hold of that supervising physician. So it's crucial to think about these things before you start just operating with impunity.
And one of the problems that I have with a lot of my clients, I get to them, and the first question I ask is, "Who is your medical director?" All right, and they'll give me the name of a medical director, and look, we all know the big boys and girls in this industry, but they'll give me a name of somebody, and the first thing I do is Google them, and they're like a psychiatrist or like an orthopedist or an internal medicine. And the contraindications and adverse reactions, they're not even astute enough to know how to treat. I think the practitioner themselves are more astute in how to treat it. However, when there is a contraindication or an adverse reaction that needs to be treated by an advanced level practitioner, they have nowhere to go because
Yeah.
their medical director isn't. So, Alex, this question I'll direct to you because I know AmSpa provides all different types of training. And then, how much training do aesthetic practitioners need to perform treatments? Because I don't want to be a Danny Downer. However, one of the problems I have are there are so many monetized weekend courses that are out there that teach people how to operate a laser and toxins and fillers. And honestly, when I interview these people, for jobs at other places or for clients, and they told me they got their certification, here we go, I'm not going to name the place. And I ask them, what is the name of the laser that you use? I don't know. All right. They don't
Hmm.
even know the name of it. What's the fluids? Is it an erbium? Is it a egg? I don't know. So that's kind of dangerous. So, as an attorney and in charge of AdSpot, how much training do aesthetic practitioners need to perform a treatment? And I didn't ask Brad because I know I was going to get the answer. It depends.
Well, it does depend. Um, but I'm glad you asked that question, because it's something that whenever Brad and I do presentations together, and we do them frequently, it's always it's always something that folks want the bright line answer, right? They want to know, I've got X number of hours, I've done these number of courses, therefore I am competent and I'm quote certified, I can go ahead and do these treatments. The truth of the matter is, it's just not that simple. Unlike a lot of other verticals in medicine where there are board certifications, right? So you can have a board certification in orthopedics or cardiology, whatever it might be. That doesn't exist. So there's nothing prohibiting a physician, like you said, whether it's a psychiatrist or a heart doctor, to become an aesthetic physician. Now the question is, if you're going to do that, how much training do you need? And there's not an answer for that. I wish there was just a really good
Alex, I'll
answer.
interrupt you for a second because those doctors that you just mentioned aren't aesthetic physicians. They are boarded, and in their
That's
professional
right.
board certification, they're just being used because it's MDDO.
That's right. That's exactly right. Because there is no board certification in aesthetics, right? A doctor, just like a lawyer, can really practice in any field that they want, provided they are trained and experienced, and they believe through their training and experience they can meet the standard of care for those particular treatments. So when we get questions about how much training do we need, I always kind of chuckle because there's no answer, and I always say, as you want to get as much training as possible, and the real answer is, and this tends to work for physicians especially, is the real answer is you want enough training where you can prove to a medical board, if you're being investigated, that you had enough training to complete that treatment. And that's not, that's not a satisfactory answer to a lot of folks, and I get that, but it's the truth, because it really is this kind of amorphous standard of care term that we use, which is the physician has to act under the standard of care. And so for them to be able to perform a treatment, they need to be able to act under the standard of care, and they need enough training and experience to be able to do that. And that's not something that is defined. It just needs to be, but it is something that you need to be able to prove. So if you're investigated, all those courses that you took, all the hours that you've practiced, all of those things you need to be able to show to the board, say, this is why I am able to perform this treatment, number one. This is also why I'm able to delegate that treatment to somebody else who can do it, and I'm capable of supervising and handling any complications that come up. Brad, we always laugh about this because it really is, it's a tough question to provide guidance on, because there really isn't an answer. I think a good way to do this, though, for those of you who are physicians or providers, just go back to what your specialty is, like what your actual board certification is. If I was to ask you a question in that certification, I would say, how do you know that you can perform a physical exam for a heart check? You have an opportunity, because you're part of that particular board. You know the answer. That's kind of how I have to look at it from aesthetics, even though there's not really a board for aesthetics. And that's something that I think would be very helpful if we could develop that at some point.
Well, I just want to
And
say you have to be careful because the AACS would probably tell you that's not true. However, there isn't an ABMS recognized board because the board of laser, the American Board of
Sure.
Laser, then the American Board of Cosmetic Surgery, although people recognize them as boards, they are not recognized by the American Board of Medical Specialties. And in certain states, you're not even allowed to mention them as being board certified. Go ahead,
right.
Brad.
Yeah, and I was going to add to Alex's point, two points, and to your question earlier. I can give you examples. So a lot of time people are like, well, can you give me an example of how that's worked? So client in New York who's a dermatologist, and he has many different practices, and when he's training a nurse practitioner to come into his practice to inject, he doesn't care how much experience she has. She must shadow him for at least 6 months before he feels comfortable that that person knows what they're doing. So even no matter how much training, whether he's doing the injection because it's a very precise way, and then he watches her or him do the injections. So again, this doctor is like, no, at least 6 months, and if I don't trust them, they're not working for me. So that just shows you like his perspective about what he likes to have and his. So again, going back to the doctor mentality, and I'm not picking on anyone else. This is a doctor story out of Chicago, and Alex knows this story pretty well too. Is we had a spine doc reach out to us. He was slowing down on the surgeries and said, I've been reading all about these cash-based businesses, med spas. I'm very interested in it. But I don't know much about that field. And I said, great. I'm glad you're asking us these questions now, but you can, as to Alex's point, you can 100% own the med spa because he wanted to get into the cash world, but he didn't know how to do it. But one of his good friends was a dermatologist. So that even though the doctor owned 100% of it, he had a dermatologist come in and be the supervising physician. And over the next few years, so this is years ago now, this doctor did get studied up and shadowed the dermatologist and took courses so that when he finally started being the supervising physician, we all felt comfortable, including he. It's his license, not mine, not Alex's, not anyone else's, that he felt comfortable that he had enough training to be in a defensible position in front of that board. So that's, again, to Alex's point, that was his reasoning as to why he felt good about it.
Beautiful. You just brought up another subset question from a subset question. All right. Is there a difference between a supervising physician, because you just brought up something, and a medical director?
You want to take that?
Do you want the depends?
It depends.
I know one. I know one can be the other.
Yes.
All right.
And so in some situations, the terms of art. So a medical director sometimes in certain states is a requirement. So if you have like a laser hair removal here in Texas, you must have a quote medical director. Well, what is that job of the medical director? Sometimes the job of that medical director is to be the supervising physician of that. Some of my larger clients, they may have a chief medical officer who has a medical director agreement, but because they're so big, that doctor cannot be the supervising physician for every single location.
Correct.
And so they start finding other doctors to act as supervising physicians in the Alabama location and a different doctor for the Florida location. Again, so that just starts getting to the details. But medical director doesn't always mean that they're a supervising physician of that individual or who's doing the injections. But ultimately, the medical director would be, again, the one responsible making sure that all medical services being performed there are at the same level that should be to meet whatever the consistency with the state laws.
Well, Alex, let me jump to something else that just came out of this. Why is it that in certain states a doctor can have unlimited amount of spas or practice? They can be a medical director, but in that same state, if you're a dermatologist or a plastic surgeon, you're limited to the amount that you can supervise. Why is that? I would think it should be just the opposite, that your best medical director of aesthetic cosmetics would be a dermaplastics or facial plastics, ocular plastics.
Right. No, I mean the realistic answer is that because the lobbyists haven't quite got that figured out yet, and the legislature hasn't been convinced enough to make that change. I think um, your point is a good one, though. I would hesitate though to say that even in those states where it's quote unquote allowed, technically speaking, if you're a supervising physician supervising, 50 locations, I think there's some risk there, right? There's some risk there. And I don't care how good a doctor you are, it's just not physically possible to be able to do that. But the truth is that the laws in these individual states that operate like that just haven't caught up with the practice yet. Law moves very, very slowly. The way the laws are written now, they are designed for things like dermatology, and things like traditional areas of medicine and aesthetics, other than plastic surgery and dermatology, really is not a traditional area of medicine, and that it's relatively new, right? So we're still trying to get those laws to catch up and to actually address the way that the business and the medical practices work. That's going to take some time. It's something that we are working on all the time, and it's really, really tough and sometimes frustrating, not only from a question like the one that you asked, Jay, but also from the other side. When you have a perfectly capable physician who is trained in aesthetics, is doing everything right, but you have a medical board or a nursing board who comes in, doesn't necessarily know how it operates, and can't figure out why it is that a general practice physician or a ER doctor is now a medical director for a med spa supervising a bunch of people doing aesthetics. In their mind, it doesn't make sense, and so it becomes an issue. So there's a lot of work to do. But I will say the most important thing is most physicians, I think, Brad, I would love to hear kind of your thought on this. Most physicians, when you break it down for them and ask them, look, are you able to supervise these particular procedures in this amount with, whether it's 50 locations or 2 locations, most physicians in their training can break it down to, okay, what training do I have? Am I able to supervise? Am I able to handle complications? Am I able to prescribe things to help with complications? And if there's just too much, or they don't have enough knowledge, they're going to say no. And so that's kind of where it comes down to, because oftentimes the board and the laws are not going to comport with how it's actually working.
All right. So let's jump to the next equipment, medical equipment. We go to all of these conferences, and when you walk onto the exhibit floor, I'm telling you, you don't know one box from another. They all look alike. They're FDA approved. They've gone through the 510K approval. And now I lecture internationally, whether it's in Europe or Canada and South America. And then I see a whole bunch of other machines that are not FDA approved. I'm not even talking about off label. All right. So does your the med spas comply with state and federal regulations? A, they should be FDA approved, and all equipment should be properly maintained, and procedures have to follow both the state and the federal regulations so that there's no violations from the FDA. I guess one of my major questions would be, how do you ensure that the people are knowledgeable?
You might take it first, Alex.
Yeah. No, please go ahead.
Like,
Although
for
I would
example,
love a
in
little
Florida,
clarification.
but
Yeah.
let me give you an example. In Florida, that when you buy a laser, and laser companies do not tell people this, you have to file a document with the Florida Bureau of Radiation Control. I call it cradle to grave. You have this make, model, serial number, fluence levels. You have to send it to the state. They stamp it and they send it back to you as received. I can't tell you how many times I pick up clients, they have no idea what I'm speaking about. And there's other states the same way. How do you ensure your clients, Med Spa, Am Spa, Brad from Byrd Adatto, that they're knowledgeable about this until they come to you with a problem?
Yeah, to that point on the, I'll address that one first, and then the secondary part second. Yeah, that's a hard part, because not one of the things you said earlier when you were starting this is every single state is going to be different. In certain states, when you do have lasers, and depending on the type of laser, there is a registration process. It's just a kind of it is compliant, and I do know where people get reported to a lot of times it's the person they're reporting to is a competitor or their angry patient or whatever it is, saying this place is not certified to have that laser. They have not filed the proper paperwork. That doesn't change the fact that the doctor knows how to properly use it. The individual knows how to properly. It's a paperwork compliance. And to your point, Jay, it would be beneficial to the laser companies to make sure that part of that sale process, they tell them that. I know that ANSPA has a lot of paperwork out there. I know when we've lectured on that, we've talked about it, but it is word of mouth, unfortunately, Jay, more than anything else. But to your point about the type of equipment, I think I should have said this at the very beginning, that no matter what you want to say, you're in the practice of medicine. You can call it a medi-spa, a med spa, a wellness clinic. I've seen all the different names. And because you're in the practice of medicine, no matter what you say, this person's waiving their rights, that I'm using a machine that's not FDA approved, or they're paying me cash and therefore it's okay. I've heard all those kind of exceptions. None of that's correct. And you were saying this, and I think this is where you're going with this. When you're having equipment in your medical practice, your med spa, it must be FDA certified to be utilized. And I know there's a lot of machines out there that people are selling, and they actually are saying they're not FDA approved, and therefore it's okay because you're using it for off-label. That's not how it works. Or you're importing something from Korea that's used all the time in Korea. You've trained on it in Korea, and therefore you want to use it in your practice. Again, that's a federal issue. It's more than just even a state issue. And so you can't even start going to the off-label until you make sure it's FDA approved to some capacity. And I'll give.
And how would a client know that? They go to a conference, they're fed a bill of goods. You see it all the time. I happen to think that the ones that we see domestically, they're legit. Even if I don't like their laser, they're legit.
Right.
But I go Canadian, I go South America, and there are good machines. They're
Yeah.
just not FDA. How would somebody know that? If I'm buying it, let's say, hey, here's an example. I'm buying it from Dr. Alex. How do I know if it's FDA approved or not? And then I'm liable. How do you find this out?
Yeah.
It's coming from Dr. Alex. It's good. Trust me.
Well, and to your point, Jay, I think number one is, obviously they should listen to this podcast, and then they'll get the information they need. They know that they had to stop and hit the pause button when they are going to international conferences. The vast majority, and I'll let you speak to ANSPA, but I know a lot of these different organizations, they vet who's showing up and who's selling product at their place, because they don't want their clients to their attendees to have issues that there's a laser being sold there, but no one can use it ever in the United States. So why is that laser here? So I know that that's part of their process. But and then to the compliance question, unfortunately, that's going to be one of those. If I'm buying it from Dr. Alex, I should go to that process to make sure, is that equipment certified? Does it meet the rules of being FDA approved? So that, I mean, it is. Hopefully, they hit the pause button before they make that purchase, because these purchases tend to be very expensive.
Very expensive, and we see a lot of secondhand equipment on the market. We all know all the name brands, but there's some that I don't even know. So let's get now on. So how do you manage? This is a big thing today. How do we manage the patient expectations and maintain treatments during the efficacy during drug shortage? For example, the FDA's current shortage on tirzepatide and semaglutide. All right, with these big weight loss, there has been a lot of conjecture whether compounding pharmacies are allowed or whether they're not allowed. I've seen some conjecture from some attorneys that said it is on the shortage list. I heard somebody said that they're not. I have two clients that received a cease and desist from a law firm saying that they need it in writing that they're going to stop marketing it. All right, it's no longer on the shortage list. I've done investigations myself. I see that it is on the shortage list. And then, of course, you call another law firm, it's not on the shortage list. I know it depends. I'm looking for an answer for the people listening.
It doesn't depend. This is the weird area of the FDA law. So on the FDA law, there is a shortage list, and so when a drug is moved over to that list, it sits there into a time in which the FDA thinks, hey, based on all the actual the producers of this particular drug. So let's use Eli Lilly. They're producing this drug. They hits the shortage list. This allows pharmacies to compound their all the ingredients they say to do A, B, and C, and D. And by doing that, they can now compound it legally. Eventually, based on production, it goes from the shortage list to the available list. So when that happened, a lot of people are like, oh, it's no longer on the shortage list, and therefore I have to stop using it. Eli Lilly started sending out, I mean, we had a ton of clients getting a letter saying, you can't do this anymore, blah, blah, blah. Well, they jumped the gun because it's actually still on the shortage list technically, because available means that the FDA is paying attention to see, can they get enough of these drugs produced to then eventually move it to the resolve list. And once it hits the resolve list, that triggers a whole bunch of stuff I won't bore your audience with today, but that's the 3 steps. So right now it's on the available list. That does not change what compounding can do, and it does not change as a practitioner what I could do. Where most practitioners, Jay, got in trouble was they were marketing that they had that particular drug at the practice, and they don't. So that's on the medical rules. It's false, deceptive, misleading to say I'm going to give you this drug. You're actually getting a compound version of that drug. I do know investigations that have gone on where if the doctor didn't disclose there was a compound, so again, if you're out there using it, you must disclose that to the patient, explain to the patient what is compounding and what does it mean. You definitely want a written consent that they understand that they're getting a compounded drug and not the actual drug. And then that means on your marketing material, don't have them up there. A lot of my clients now just says weight loss drugs or compounded weight loss drugs. You can sit there and describe to them what it does, but again, be very, very careful about how you're promoting it from the marketing right now. Everything else is just white noise when it comes to the shortage list.
All right. We'll jump to another topic. I know that I've been on some panels with you, Alex, and I teach this at the university, HIPAA. Back when this Portability Act first came out, people have said, no, HIPAA is only if you take insurance, because that's why it's called Health Insurance Portability Act. All right. I'd like you to really give the reality of violation of protected health information for anybody and the fines that are massive. This is not a state regulation, this is a federal regulation. So, ensuring that there's documented protocols for patient consent and confidentiality. Can we speak about that for a second? For clear procedures for obtaining the consent, keeping the health information confidential, and remembering HIPAA standards. And,
Hmm.
when we talk about the consent for a second, I hear this all over the place. If you have a consent, do you have to consent to each and every treatment, or does there a master consent? Example, you join a Botox club or a Dysport club. I want a Xeomin club. I want to be fair to all of them. And I sign the consent. I'm aware of the contraindications. And then I come back for the next treatment. All right. And I don't sign the consent because it's the same procedure. And then the nurse practitioner says, you could use a filler in your nasolabial fold. Now you've already done a different procedure, not under the same consent. Can you elaborate on that?
Yeah, so there's two things there. One is the HIPAA question and the patient confidentiality, and then consents are there's obviously part of HIPAA that come with consents, but there's also consent to treatment. So taking your later question first, you're absolutely right. When patients need to be able and are required to consent to the treatments that they're getting. Most of the time, that doesn't mean a general consent is going to cover everything. I would not be comfortable with that, particularly given all the different drugs, particularly given that your condition can change when you come back. So when you're consenting to a particular procedure, what that means kind of in layman's terms is that you're being given all the information to be able to make an informed decision about whether or not you want this particular treatment. Now, if you come back and they say, well, we're going to do something else, or there's something, or potentially there's been a change in your health history. We always use the example, well, you're pregnant, or
Pregnant.
you
Yeah.
had a stroke, or whatever it is. Things have changed now, and so those disclosures need to be made over again. There needs to be another consent where you're consenting based upon all of those new things. Again, it's not necessarily that you have to do it every time, but it's good practice, because it more than anything, and Brad can attest to this, is if it's not written, if it's not recorded in the medical chart, it's like it didn't happen. So the reason that these consents are kind of used, like when you go to the doctor now, oftentimes you're signing the same thing over and over and over again. You're like, man, I've already signed this thing a million times. Well, in many ways, they're covering their ass, saying, well, yes,
Yeah.
you signed it this particular time. And then when it comes to HIPAA, it's again, HIPAA is all about patient confidentiality and making sure that the patient's medical records, the patient's information are protected. You're absolutely right. There is an argument to be made that cash-based practices in aesthetics aren't necessarily covered and subject to the federal HIPAA law. However, that is basically a bit of a red herring, I think, because what we're seeing is, number one, all of the states have their own patient privacy laws that tend to be as strict, if not stricter, than HIPAA itself. And we're starting to see every now and then, when this issue comes up, we're seeing judges, or we're seeing enforcement actions cite to HIPAA as being the standard of care, meaning that if you're not adhering to HIPAA on a federal level, you're not really taking the type of care that needs to be done. I'm not sure about the actual penalties and provisions. Hopefully, Brad knows everything; he has everything memorized, so I would ask him about that. But I know they can be extreme. I know that getting any kind of the part of the problem with getting a HIPAA violation, if it's actually HIPAA on the federal side, it's not just the fines, it's the obligations that you're now required to take as far as disclosing and reaching out to folks and making sure that you're publishing what happened. And it can be really, really, really time consuming and costly, and it can be debilitating to a practice. Brad, did I
Yeah,
get that right?
Yeah, good job, Alex. I'll
Thank
give you
you.
a thumbs up. And I want to add some stuff to what Alex said, which I think is really important to your question, Jay, which is a lot of times when a patient comes in, before the practitioner touches that patient, there's a general consent. The general consent is that you agree to come in, and if they have to do it for their examination, they might have to touch your skin to see how it responds. You want that general consent. So that's consent. Where, to your point, Jay, is after that, it's an informed consent, which is okay, now that we know you're a good candidate for this service, the laser, the Botox, whatever, we now to make sure that you understand what are you about to have done. So if I only came in and I was cleared for that under informed consent for that laser, but the next time I come in, I want an IV, and the next time I want to come in, I want to have Botox. Each one of those, there should be a good informed consent in which I was cleared properly by the physician, nurse practitioner, or PA, and that I understood what I was getting into. Now, if I come in and they say, Brad, you're going to be a great candidate, we got to remove that tattoo that says I love Alex on your arm because I know you don't like it anymore. It's going to take it's going to take 6 times for us to get it off. Now, they've put that together. So I'm going to come in for 6 different times. I understand that they're going to keep firing the laser till it goes away. And every single time I come in, before they fire that laser, they should ask, is there any material change in your health? That's the question they ask, and nothing else has changed. We can continue through this treatment plan that we have to fire that laser. I come in, that goes, any material change in health? No, but I got really burned. I was out, in the Florida with Jay on his boat, and we had too many cocktails. I forgot to put sunblock on. I don't think you're a good candidate today for this. Let's pause. I'm going to get you back with a nurse practitioner to make sure when can we start this laser process again? Because I don't want to fire a laser on burned skin. Again, those are material, and again, material to the point of how it affects that particular procedure. So, I have a head cold might not be enough to say, oh no, you're fine. We can keep going. Material to what that is. And to Alex's last point, yes, I totally agree. HIPAA does exist on the federal laws, but every single state already has their own we call baby HIPAA, but state version of that. Many of them have higher fines and higher issues that you have to abide by. And then that standard is really being set by different courts. Some states have allowed it, like Arizona. I know is one state where plaintiffs' attorneys sued the doctors and saying, this is the standard that you have to follow, and you didn't even come close to it. And so the judge was allowing that in as the standard for that breach, saying that you the practice, even though you don't have to follow it verbatim, you should have at least had some of it. And so that's the HIPAA and understanding how it's applied.
Yeah, I don't even want to get into reviews and HIPAA because we speak about that for hours, and I'll
Yeah.
leave that to Jeff, all right, to speak
Yes.
on that. But it becomes a nightmare about violation of HIPAA, or sometimes violations of terms of service. I don't necessarily agree that it's not fair for the doctor to respond when a patient actually calls you out, but that is the law.
Right.
Let's talk about professional liability, aka malpractice insurance. We have to confirm that med spas and medical practice carry the adequate amounts of malpractice professional liability, because here in Florida, the minimum would be 100, 300, and it could be 250, 750 if you have an OR. And here in Florida, you do not even have to have malpractice insurance, professional liability. You can either post for personal financial responsibility, an irrevocable letter of credit, or have a policy. Now, if you post personal financial responsibility and you're called to task and you can't pay up, you lose your license. All right. So, and they also have different, like if you're hit for 3 malpractice claims by a court, on the National Practitioners Data Bank, you can also lose your license. Let's talk about malpractice insurance and who it covers, whether it covers the PA, the NP, the esthetician in your practice, or whether they should have their own policies. Let's start with you, Alex.
So it depends. However, what I will say is that first of all, you should definitely have malpractice insurance. I don't recommend not carrying insurance, not carrying adequate insurance. So there's different types of insurance that cover different things. This isn't exactly my expertise, but what we have been finding is that there are insurance companies that provide a medical malpractice policy for everything that happens under the roof of that medical spa. So all the treatments that are happening, provided you're disclosing what all those treatments are, you're meeting all the conditions, that should cover what happens under the roof of that medical spa. However, a lot of physicians have their own individual policies, and that's not a bad idea, because the more insurance the better is what many people say. When it comes to other types of practitioners, like nurse practitioners particularly, and PAs, typically they are going to be if there is a policy, they are going to be covered under that policy of the medical spa. The problem is that unless you get your own policy, right? You secure your own insurance policy. You're relying on other people to make sure that everything has been, all the I's have been dotted, the T's have been crossed, the bills have been paid, everything is being disclosed properly. So it's not necessarily a bad idea to have your own policy, but the main thing when it comes to insurance is in this area is you've got to make sure that you are completely forthright with the carrier on everything that you're doing, making sure that you understand it. Because where we see folks get into trouble in this industry is that insurance is, they think they have insurance, but when it comes to a lawsuit or a particular claim, it turns out they don't, because for whatever reason that carrier says, well, we're not going to cover weight loss, we're not going to cover IVs, or you didn't tell us about this. And that's where you get in trouble, because this is it's a unique area for the insurance carriers too. They're still learning the ropes in this. So you've got to be careful, and you've got to be totally forthright and just make sure that you're disclosing everything. You're not hiding anything at all, and you're completely transparent in how you're behaving.
Yeah, that's a great point, that when you have a policy, it has to list what the coverages are on the declaration pages so that you don't think, I thought, he said, she said, and then that person is gone. I'm going to ask one more question before we wrap it up, because I've got dozens more questions. We just don't have enough time, but that will be for part two. All right. So, how much freedom do independent practice nurse practitioners or PAs have? This is another one of these things that, in certain states they're going to have and be able to open up their own. In California, they're allowed to open their own. In this state, they're not. You need medical directors and delegation agreements. Where are we going with this?
Brad loves this question. It's like his favorite.
So this is a hot topic, as you can imagine, Jay, and it's because basically there's three ways that a nurse practitioner can get independence. I'll focus on them first because that's where the trend is going. And so, generally speaking, it's by the fact that you have a license. So you're in Nevada and you get licensed there. You're independent and autonomous, meaning that you can do a host of things under your particular license. The next level is what's happening in Illinois and Florida and New York and now California, where after practicing under the proper supervision and delegation for a certain time frame, you can then get your independence. And the third one, which is not as relevant, is it's because the area meets certain criteria. Normally, it's out in the boonies, and that because of the way it's been delegated, you can practice there without as somewhat independent. But that's the three that we typically look at it. What's the fascinating part is we saw this happen in Illinois, and now we saw it in Florida. I'm having the same conversations in California and New York. Is a lot of people see, oh, they passed the law, and therefore I can go become independent. It's like, no, 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 no. That's what the statute says. Now we have to wait to see how's the nursing board say you get independence. And that's the most relevant piece. So in Illinois, we had a bunch of nurse practitioners that were jumping the gun because it said that they passed the law and the governor signed it. But the nursing board finally said, no, 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 you have to do this many hours, this many credits, and then apply, and then you get your independence. So it's not by fiat, like again, going to Nevada, all I have to do is get a license and I'm independent. There's a whole process that you have to go through. It's like, you can't skip it. You have to go through that route. And there's arguments in New York and California as to when does that start or stop. So it's gray as Mississippi mud.
Yeah, it's
All
very
right.
tricky, Jay. And what I would recommend for everybody, if you're an NP or a PA in one of these states, you've got to move with caution in this, because we get questions all the time on this. The truth, it's not just that the rules have to be set, which is true, but then how are those rules going to interact with other things like medical advertising? There are some states that say independent NPs shouldn't be calling themselves medical directors or shouldn't be operating a medical spa because it's the term medical as opposed to nursing. And we're not sure how this is all going to play out. So it's kind of in real time starting to shape up, and it's going to take a little bit of time to unwind this. So as excited as all the NPs and some of the PAs are to get out there and be independent, it's there is some risk there. And until we understand what it's going to be, and until the boards understand how they're going to enforce it and how the penalties are going to happen and what they're going to investigate, there is some risk there, and I would proceed with caution.
All right, ladies and gentlemen, we have reached the hour. My, how time flies when you're having so much fun. So let's share how they can get in touch with us. I do have one note to announce that yesterday, Shorr Solutions, my practice management company, received notification from Informa, who has the AMWC, VCS, the aesthetic show, that we were nominated and voted as the Best Practice Management Company of 2024. This is my fourth time out of 6 years winning that. So thank you
Congrats,
to
Jay.
all of you out there that have voted. Thanks for the confidence, Alex and Brad, that we work together with all of these things. It can't be done without every one of you. So if we can throw that slide up, you can contact me. That would be Shorr at Shorr Solutions, plural, because we have more than one solution. All right. Our website is www.shorrsolutions.com, and all of our social media handles are at Shorr Solutions. Brad?
Yeah, and for us, the easiest way to get a hold of us is at info@byrdadatto.com. If you reference the fact that you saw this video or listen to the podcast, my team will send up a consult gratis so that we can kind of help answer any questions that you had left that we didn't address today.
And lastly, Alex.
Yeah, and for me, info@americanmedspa.org. I'm seeing you've got my website is shorrsolutions.com. Jay, you trying to circumvent and take over my entire
Well,
um
that is
so it's
technology error at its worst. So what is your website?
yeah,
That's
no,
good.
it's
It should
fine. It's
be Adatto too.
It's well, you can certainly meet me there, but the main spot is americanmedspa.org, americanmedspa.org. That is the AmSpa website. And Instagram is where we spend most of our time when it comes to socials. You'll see it there, but our social handles are there as well. Info@americanmedspa.org will work. But yeah, and you know, you reach out to Jay, he'll get a hold of me too.
I think that was put in there because I'm trying to scrape some change together to buy AmSpa. So maybe that was the reason for that, huh?
Yeah,
I'm
no, I
just
think
like,
that's yeah, yeah. No, I
I'm
mean
only
well, then you
like,
better keep that tattoo on your back then, Jay.
yeah, I'm only multi-million short, but I'm getting there, okay? So, ladies and gentlemen, thank you for spending the hour with me, with my colleagues Alex Thiersch from AmSpa and Brad Adatto from Byrd Adatto. I really look forward to having them back on part two for the parts that we didn't cover. Until then, I won't see you for the rest of the year probably. Have a safe holiday season. Good luck and God bless.